Did you understand in count one, you're charged with assault, family choking, strangulation? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Janelle Garza. All right, has a warrant. Last time she had a warrant, and counsel here on this side. So Deputy Laura, does she have a warrant or no?
No, Judge, she was in custody and when she retained me and she's since bonded up.
Okay. All right, so have you received all the discovery?
We haven't, Judge. We're in agreement with the state on a 30-day reset. They need to give us some discovery as to restitution and additional information in regards to the vehicle and from the UUV.
So Judge, defense brought it to our attention, there was a case where the vehicle in question was involved at a later date. What I'm gonna do is link up the e-discovery in that case and sync it up to this one to where it should all transfer over the next couple days. We're also reaching out to the complainant in regards to restitution. They did give us a prior figure, but it's one that I just had a few questions for them on.
All right, Ms. Ferguson. On this case, give them a 40-day reset. Y'all need to confer off docket. So at that time, either you're gonna plea or either it's going to jury trial. And when I say going to jury trial, that means it'll be going to jury trial the next day. You understand? All right.
Thank you, Judge.
November 6th.
All right, November 6th.
Judge requested 40 days. I'm sorry. I'm just concerned that we're going to be able to hit that deadline. I think 40 days.
Oh, they'll be able to hit that deadline.
In 30 days?
Oh, yeah.
Okay.
All right, if you'll sign the reset form.
Yes, Judge.
Yes.
I'm sorry. When are we coming back? November 6th for a plea deadline.
And jury trial. All right, who is here on Aaron Alvarado? All right. Court is calling 2023 CR 5315, State of Texas versus Aaron Alexander Alvarado. Can I have parties announced for the record for the state?
Travis Banks, the state of Texas.
Defense. And are you Aaron Alvarado?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Alvarado, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do.
State, are you proceeding on the indictment as presented?
Your Honor, the state will proceed only on count one, waive and abandon count number 2.
No
Any objection? Off the record for a moment. Ms. Ferguson, I need a PSI date. All right. All right, Mr. Alvarado, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count one, you're charged with assault, family choking, strangulation? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Sure.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Alvarado, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I'm sorry, what was that?
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes. I did.
According to plea, state is proceeding on count one. Punishment is to be assessed at a cap of 5 years in the prison. The state is silent on your recommendation. I'm sorry, the state will make no recommendations and they're silent on your applications. They will take in consideration night mag number 691315. Did you understand that to be the plea?
Yes.
Defense,
Yes.
state,
Yes, Your Honor.
showing you the waiver of appeal paragraph. And I'm sorry, let me backtrack a little bit. Because it's not a part of the plea bargain agreement. But do you understand if the court finds that this is a family domestic violence case, there will be an affirmative finding of family violence?
Yes, Your Honor.
And did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, sir.
Knowing that, do you still wish to continue with the plea?
I'm sorry.
Knowing that, do you still wish to continue with the plea bargain agreement?
Yes, sir.
Showing you the waiver of appeal paragraph, did you review that with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea?
Yes, Your Honor. So you offer State's Exhibit 1 and its attachments.
No objections, Your Honor.
All right. And state, have you been in contact with the complainant?
On this one,
Yes.
she's incarcerated at the moment.
All right. Thank you. Mr. Alvarado, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, Your Honor.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. We will come back on November 13th. At that time, I'll make a decision on your application based upon the evidence that's presented to me and based upon the PSI report. Do you understand?
Yes, sir.
Counsel, does he need a TAP evaluation?
I would imagine that would be.
Okay.
Yes, Your Honor.
Any mental health issues?
Not to my knowledge, Your Honor.
All right. Have you ever been diagnosed with any mental health issues?
No, ma'am.
Have you ever been on any type of mental health medication?
Yes, ma'am. I have.
All right. So what I'm going to request is a PSI, TAP evaluation, and a MIC. Is there anything else? So they're going to come see you for the mental health evaluation, TAP evaluation, and a PSI report. Do you understand?
Yes, ma'am.
All right. Is there anything else?
Nothing further on.
All right. We'll see you back then. Thank you. And Bridget, is there a chance that he's going to bond out?
No, Your Honor.
Okay.
Be custody for 7 months.
All right. Thank you. All righty. Yeah. Yes. It's a lot. It happens a lot. Yes. Okay. Oh, this one is done. Yes. All right. All right. So I'm being told we have some pleas, so I'll take those up. And then anything else is going to have to come back this afternoon. Then, of course, one staple in court is the hand sanitizer, because we have so much paperwork that we're dealing with and exchange hands so much. And my mom sometime will call me. She's like, you touch your eye and you touch paperwork. I'm like, I'm working on it, Mom. Yeah. Oh, yes. Mhm.